You know, the U.S. asylum system used to be seen as this humanitarian lifeline. But wow, by early 2026, it had morphed into something completely different, basically an enforcement machine. So today we're going to dig into the data and see exactly how this radical shift happened and, what it actually means for millions of people.
Okay, so it really all starts with this one number, nearly 3.4 million. That is the absolutely staggering backlog of immigration cases pending in late 2025. And we're not just talking about a long line here. This is a bottleneck so bad, so severe, that it's kicked off this whole cascade of aggressive new policies. And they all have one single goal: clear that docket.
And for the asylum seekers caught in all this, the consequences have been, well, they've been stark. By January 2026, the approval rate just plummeted to less than 3%. I mean, just think about that for a second. Only 1 year before, it was at 18%. So this wasn't some slow, gradual dip. Nope. This was a complete and total collapse.
So, you gotta ask, what's behind all these denials? Well, in a lot of cases, it comes down to one thing: fear. The rate of asylum seekers who just missed their court hearings, it actually doubled in a single year. And here's the kicker: when an applicant doesn't show up for their hearing, their case is pretty much always closed out with an automatic deportation order.
So when you put all these numbers together, this massive backlog, the approval rates hitting rock bottom, and the huge jump in no-shows, it paints a pretty clear picture, right? We're looking at a system that has just completely buckled under the pressure. Get this, the average wait time for a hearing is now sitting at around 900 days. And because so many people are missing their court dates, a mind-boggling 41% of all cases that get decided are closed out because of abandonment. So what you get is this vicious cycle where the docket gets cleared, sure, but not based on whether a case has merit. It's just happening by default.
So, to deal with this crisis, the government has totally switched gears. They've rolled out this new, really aggressive strategy. See, it's not about managing the backlog anymore. Now, it's all about actively, and I mean actively, weeding cases off the court calendar as fast as humanly possible.
And if you look at the official language, it tells you everything you need to know. The new priority is rapid finality and removal. That phrase right there, that's a huge tell. It's a fundamental shift away from looking at each case individually and toward a system that's all about efficiency, speed, and enforcement.
So, how are they actually pulling this off? I mean, what does this look like on the ground? Well, the government is using a kind of toolkit, 3 specific legal and procedural tactics, all designed to speed up deportations.
All right, first up in the toolkit is something called the tactical motion to dismiss. Basically, an ICE attorney can just ask a judge to dismiss a case from the normal court docket. But now here's the catch. It doesn't mean the person is free. Not at all. It means they get immediately punted over to a much, much faster track for deportation, completely skipping a full hearing.
And this whole thing happens incredibly fast. We're talking an ICE attorney makes a verbal request in court, the judge can say yes right then and there, and poof, instantly that case is gone from the court docket, and that person is on the fast track to being removed.
Okay, tool number 2 is called summary pretermission. This gives a judge the power to just look at an asylum application and throw it out on the spot for being legally insufficient. And a lot of the time, this is for technical stuff, like a form wasn't filled out perfectly. This happens before any evidence is even shown. It's another way to basically end a case before it even has a chance to get started.
And here's where you can really see how these tactics all feed into each other. When you take these super fast dismissals and you combine them with aggressive enforcement, we're talking ICE making arrests near the courthouses. It just creates this climate of fear. And that fear directly drives up that no-show rate we were just talking about, which, you guessed it, triggers even more of those automatic deportation orders.
All right, the third and final tool in this kit. It targets the last line of defense for a lot of people, the appeals process. There's a new rule for the Board of Immigration Appeals, or the BIA, and it completely changes how appeals work. The bottom line? It makes it way, way harder to challenge a judge's first decision.
This new rule also puts a ton of pressure on applicants. And one of the biggest changes is just the timeline. The window you have to file an appeal, it's been slashed from 30 days all the way down to just 10 days in a lot of cases. I mean, you can just imagine the incredible rush that creates for people and their lawyers.
So now, under this new rule, the default outcome for an appeal isn't a full review anymore. It's just a summary dismissal. In fact, it's estimated that something like 90% of appeals are going to be dismissed just like that. Only a tiny fraction will ever get a full hearing. It's like the system is now designed to reject appeals, not actually consider them.
Now look, these docket-clearing strategies are definitely efficient. No one's arguing that. But they also come with some really significant human and legal consequences, and that's put them right at the center of a very fierce debate.
And this really gets us to the heart of the whole debate, where you have these two views that just can't be reconciled. On one side, you have proponents who argue, hey, these measures are necessary to filter out frivolous claims and bring some order back to the system. But on the other side, critics are saying, whoa, hold on. This stuff erodes fundamental due process rights and puts real refugees in danger, especially the ones who can't afford a lawyer.
And it's not just those three tools. These main strategies are being backed up by a bunch of other policies. For instance, the government is hiring more judges, and a lot of them come from prosecution or enforcement backgrounds. They're also being given quotas for how many cases they need to complete. Add to that new restrictions on work permits, and even reopening old closed cases. All of it just adds more and more pressure on asylum seekers, maybe to the point where they just give up their claims.
So, if you step back from all the legal arguments for a second, the source material points to a really clear human toll. The end result of this super high-speed enforcement-first system is this widespread fear rippling through communities and has turned what was a humanitarian process into something that, for a lot of people, just doesn't offer a realistic path to safety anymore.
So when you put all these pieces together, what's the end game? What's the ultimate result? Has this really aggressive new approach actually solved the crisis in the asylum system? That's the big question.
You know, at the end of the day, what we're looking at here isn't some accident or a slow, gradual evolution. It is a deliberate, strategic pivot. The main goal of this system isn't really about managing a backlog of individual humanitarian claims anymore. Now, it's all about aggressively clearing that backlog using dismissals and enforcement.
And that leaves us with this one last, really critical question. Yeah, cases are for sure being cleared from the docket faster than ever. But has the problem actually been solved? Or has the crisis just been moved? Shifted out of the immigration courts and into federal lawsuits, or maybe even onto the international stage? That's the question that's really going to define the next chapter of this entire story.